Good afternoon, everyone, and thank you for joining us for today's presentation. We have almost 260 people participating from a vast range of industries. Many of you I know personally and have spoken to about these very important topics right now. I'm Patricia Reilly. I'm the chair of the Labor and Employment Group here at Murtha, Cullina. Presenting with me today are Matthew Curtin and Sal Gangemi. Needless to say, we've been studying these issues and the laws that are coming out in extremely rapid fire succession. We've been advising clients nonstop for the last few weeks, and we're very grateful to be able to share what we know with you today in this webinar format. I will caution that what we say today may change tomorrow, but these slides and the information contained in them are current as of today. This program is being recorded, and so today is March 27th, 2020. If anyone listens to it after today, I will advise that there may have been changes already. That is how quickly the legal landscape is changing. I think all of you know that you should be in listen-only mode, and I believe you all are, and I would ask that you continue in that mode. Unfortunately, due to the volume of information and the number of participants we have, we do not anticipate being able to answer questions during this webinar format. As you all know, of course, we are available to you to answer questions offline. We would ask that you email us because we are basically getting so many calls that we have to schedule them, and we will do so or answer by email if we can. So with that, I want to begin with our first slide, which is an overview, the agenda of what we hope to cover today. We're going to start with the CARES Act, which is part of the stimulus package, and we will update you with the current information as of today, but that might even change tomorrow. We will address the Families First Coronavirus Response Act, which is the paid FMLA and paid sick leave. That is probably the one area that we have received the most questions recently, and we will go into detail on that. We'll talk about business closures, laying off, furloughs. We'll mention state-specific considerations in Connecticut, New York, and Massachusetts on that issue. I'm going to hand it over now to my colleague, Matthew Curtin.
Good afternoon, everybody. Thanks for joining us. The slide that I have in front of you right now is the only graphic that you're going to see throughout this entire presentation, and the reason I put this in here is to show the stark contrast in week-to-week unemployment claims from the time the DOL started tracking unemployment claims in 1967 through today, or more accurately through the week ending March 21st. If you look at the chart, it accounts for U.S. recessions from 67 to the present. Even in times of economic recession, week-to-week claims never exceeded even 1 million claims in a week. For the week ending March 21st, claims were at 3.2 million, almost 3.3 million claims on a nationwide basis for that week ending alone. That's how hard this COVID-19 pandemic is hitting the economy and hitting employers specifically. And that really sets the stage for the discussion that we're going to have today concerning the various stimulus efforts on the federal level, the restrictions that we're seeing on state levels, stimulus efforts we're seeing on the state level, and how that all plays into managing your workplace. So we're going to go to the next slide, and we are going to discuss what is currently pending before the House right now, which is the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act, which is really phase 3 of the federal stimulus. I've been following the CARES Act up until the minute before we started. House is still not taken up debate on the act, as far as I can tell, or maybe they are debating it now, but that's how minute to minute this is at this point. The House was supposed to debate and vote on it this morning. It seems to be held up based on some procedural issues. We still expect that it will pass in some fashion. So we're going to hit the bullet points of what we expect to see when the House passes the CARES Act, assuming it does, and the president signs off on it. So a couple buckets of information here. One, relief by cash. One thing that the CARES Act would do by way of stimulus is provide direct payments to individuals that are impacted by the coronavirus. So what we expect to see is direct payments to taxpayers ranging from $1,200 to $2,400, and additional payments for individuals with children. Those payments would be phased out once you hit the 198,000 or 150,000 AGI based on filing status. So there could be checks coming your way or your employer's way over the next few weeks, assuming the CARES Act passes, but that's going to depend on income level and whether there are children in a particular household. Another thing that we're going to see in the CARES Act is relief by payroll tax, and this will be welcome news to employers. Employers would receive a payroll tax credit for half of wages paid out to employees where a company's operation was suspended or halted during the coronavirus pandemic, and that might be because of one of the executive orders or the declarations that we're seeing on state levels concerning closures of non-essential businesses or shelter-in-place orders. We're hoping to get additional guidance on that, how that payroll tax is going to play out, but still not even law yet. So, but that is one thing we expect to see. So on the next slide, you'll see that we're looking at relief by retirement account access, and this would help taxpayers directly, individually, and not employers. But what this would do is allow for individuals to take money out of their retirement accounts, and the 10% penalty that you would usually see would be waived up to $100,000 through December 31st, 2020. And the fourth prong that we'd see is relief by tax-free student loan repayment. So this would affect employers directly. Employers would be allowed to provide tax-free student loan repayments up to $5,250 per year per employee. The payments would not count as taxable income for the employee. So that would be welcome relief to individuals with student debt. Of course, the employer would have to elect to make these payments. And then finally, on the next slide, you're going to see that the fifth and final bucket of relief that we've identified constitutes unemployment. And so the CARES Act provides for temporary pandemic unemployment assistance that would last through December 31st, 2020. It would provide payments for those that aren't usually eligible for unemployment benefits, individuals that are self-employed, independent contractors, and it would relate directly to individuals that are impacted by the COVID-19 virus. It would allow for covered individuals to obtain enhanced and lengthened unemployment benefits. Benefits would be extended from 26 weeks in most states up to 39 weeks. Benefits would be could be calculated up to an additional $600 per week per individual for up to a 4-month period. There would be waivers of waiting periods, and this would all go into effect, I assume, pretty quickly after the passage of the CARES Act. And this would really help benefit all the individuals that are dealing with long wait times with unemployment, with dealing with reduced income levels based on the caps on unemployment and the caps on the length that somebody can actually receive unemployment. And obviously this is all in reaction to that spike, that enormous spike in the percentage of unemployment claims that we're seeing on a nationwide basis over the past couple of weeks. So that really is kind of a summary of what we expect to see from the CARES Act, assuming it does pass, but it hasn't passed yet, and we'll just have to wait and see what happens over the next day. So we're going to go to the next slide, and Sal is going to talk about the Families First Coronavirus Response Act.
Good afternoon. This is Sal Gangemi. So, as most of you have already heard, about a week ago, although it seems like it was months ago at this point, Congress enacted the Families First Coronavirus Response Act. Now, the act actually comprises two separate parts or two separate acts. One is an Enhanced Family and Medical Leave Act. It amends, at least temporarily, the Family and Medical Leave Act to provide for some additional coverage and additional reasons for taking leave. And then there's also the paid sick leave aspect to the act, which provides for additional pay while an employee is subject to quarantine or isolation. The act requires private insurance plans to provide free COVID-19 testing. And of course, that's assuming that testing is available. As you know, not everyone is being tested. Not everyone qualifies for testing at the moment, but that is expected to change, or at least that's what they tell us on the news. That's expected to change very soon, hopefully it will. The act requires employers to provide emergency paid sick leave to workers who are affected by COVID-19. And as I mentioned, it also expands the Family and Medical Leave Act. The act addresses increased funding for state unemployment insurance programs and other safety net programs. And Matt's already discussed that in connection with the enactment of CARES. We can move on to the next slide. The Department of Labor expects to issue regulations sometime in April 2020. The act takes effect on April 1st. So as of right now, the act does not necessarily apply, but of course you need to be prepared because as of April 1, the act will come into play. The Department of Labor has stated that it will not enforce violations of the act as long as the employer can show that it acted in good faith in complying with the act. Okay, so originally we thought that meant that for the entire month of April, there would be no serious enforcement provided that people were making good faith efforts to comply with the Act's requirements. This morning I saw something, and again, this is subject to change, but I saw that good faith non-compliance period is only extending until April 17th. So apparently the 30 days runs from March 18th, okay, through April 17th. But in effect, if it remains this way, you're only going to have 17 or 18 days to really get up to speed to make sure you're doing the right thing. The Department of Labor has issued some guidance, okay, and we've sent this out on our blogs. They've sent out a Q&A guidance, okay, involving the FFCRA or the Act. They've issued guidance regarding paid leave rights, as well as paid leave requirements. There's also a posting requirement, a notice that the Department of Labor has prepared, which should be posted in the workplace. It should also be emailed to remote workers, people who are working remotely, so that they have actually have an opportunity to see the notice. Okay, so next slide. The Act covers three different things. The Enhanced Family Medical Leave Act portion. It modifies, it expands employer coverage, it expands employee eligibility, and it expands pay benefits. In fact, as you know, under the FMLA, there are no pay benefits required. no payments required. FMLA is typically unpaid, but this statute, or the act rather, has amended the FMLA so that for certain COVID-19 related purposes, pay will be available. Pay benefits will be available. So we can go to the next slide and talk about the expanded employer coverage. Now, typically, the FMLA applies to private sector's employees with 50 or more employees, and it covers all public sector employers regardless of the amount of employees that the public sector has. So essentially, the coverage under the FFCRA now extends to all private employers and public sector employers, regardless of size. With respect to private employers, it essentially applies to up to employers who have 500 employees. So if you have more than 500 employees, okay, the FFCRA will not apply. However, and we're going to talk about this in a little bit, some states have enacted similar paid leave programs and will likely cover employers who employ more than 500 employees. So, for example, we're going to be talking about New York. New York applies to everyone regardless of size. Okay, so New York's act does apply to essentially all employees. Next slide. Typically under the FMLA, eligibility depends on an employee having worked the previous 12 months at least 1,250 hours before qualifying for leave. Under the expanded coverage provided by, or expanded eligibility provided by the Act, an eligible employee is really anyone who's been employed for at least 30 calendar days. So gone for now, or at least for COVID-19 related leaves, an employee only needs to be employed by the employer for 30 calendar days before being eligible for these benefits. And the Expansion Act has added a new reason for taking leave under the FMLA, and it's caring for a child under 18 years of age whose school or child care provider has been closed or is unavailable due to the COVID-19 emergency. Okay, and when we talk about New York, we're going to talk about a similar requirement, although it's much narrower than what the Act contemplates. In that sense, this will likely trump those requirements. So the first 10 days of family medical leave under the Expansion Act is considered unpaid, all right? But employees are permitted to use whatever accrued PTO they have for that 10-day period that is deemed unpaid under the law. In addition, they may be able to use some of what's available to them under the Emergency Paid Leave Act that Trisha's going to be talking about shortly, provided that they fall within the eligibility requirements of that section. After 10 days of unpaid or PTO paid leave, the employer is obligated to provide all full-time employees with the equivalent of 2/3 of their regular rate of pay for up to 10 weeks under the law, okay? For up to 10 weeks. Part-time employees, or those who don't have regular schedules, are paid at 2/3 of their regular rate for average number of hours worked over the prior 6 months of employment. So the pay under this is capped at $200 a day, and in the aggregate, it's capped at $10,000. All right. Small businesses, which are considered those under 50 employees, can seek an exemption if compliance would jeopardize their viability. But it's not yet clear how we go about doing that. what's happening is that Congress has sort of left that out there in the twilight, and it doesn't look like the Department of Labor is going to address what that means until sometime in April. Okay, and I doubt that it's going to be early April either. So these are issues that unfortunately we're going to require more guidance on before we're able to opine. So with that, I'm going to pass the baton, or the clicker, as they say, to Trish Reilly, who will talk about the Paid Sick Leave Act.
So
component of the FFCRA.
Yes, exactly. That's exactly what I was just going to say, Sal. The paid sick leave is actually a component of the Family Coronavirus Leave Act that you were just referencing. So this is a component of it. It applies to, as Sal just said, it applies to employers with fewer than 500 employees, and it requires the employer to pay 80 hours of sick time, which is prorated for part-time employees, and paid sick time is paid in addition to already accrued sick time. So upon the request of an employee, the employer must permit an eligible employee to use paid sick time under the FFCRA to cover the initial 10-day period of unpaid leave under the FMLA. So who is an eligible employee? Employees are eligible on day one of employment. So Sal, the FMLA component has a 30-day waiting period. Is that correct? But the paid sick leave employees are eligible on day one.
That's correct. That's exactly right.
Okay.
Yes.
Okay. Okay, next slide. Furthermore, the employers must provide paid sick time to the extent the employee is unable to work or telework for the following reasons. One, the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. So we do not interpret this to mean executive orders that governors have issued statewide. We interpret this particular component, number one, to apply to a specific person who has been ordered to be isolated. But we think that the other elements here are broad enough that most people who have some COVID-related illness are going to be covered. So number two is the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. So advised by to self-quarantine due to concerns related to. This is extremely broad, okay? So the next one is employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. Next. Number four, the employee is caring for an individual who is subject to quarantine or isolation order, which is a narrow exception, but this is broad right here. An employee is caring for an individual who has been advised to self-quarantine by a healthcare provider due to COVID-19. That's an extremely broad application of the Sick Leave Act. Five, the employee caring for a son or daughter of such employee, if school or the place of care, a daycare, for example, of the son or daughter is closed, or a child care provider of such son or daughter is unavailable. Go ahead, Sal.
So, Tricia, I just want to interject because there's been a lot of confusion. The way this law was sort of put together, it's a little confusing because of the two different components. And I've gotten a lot of calls for clients who are really trying to reconcile these two pieces. So as you can see under the Emergency Paid Sick Leave Act, there are 6 bases for qualifying or becoming eligible for paid sick leave. One of those, and that's number 5, okay, is also the subject of what I discussed earlier, the FMLA Expansion Act, because you can get for number 5, okay, you can get for number 5 up to a total of 12 weeks off, okay, with pay that Trisha's going to discuss the nature of that pay. But so it sort of covers the piece that I was referring to, okay, which is 2 weeks of pay, plus it also covers an additional 10 weeks of pay for reason number 5. And so that's part of where there's been a lot of confusion here. The act primarily, it seems to me, is mostly concerned with point number 5, and which is why only 12 weeks of paid leave under this act applies to the situation where you're caring for a son or daughter whose childcare provider or school is not available because of COVID-19 precautions.
Yeah.
Right, or to put that another way, Sal, if a person is on FMLA for COVID-related reasons, other than caring for the son or daughter because the workplace is closed, so
Right.
if somebody is on FMLA because they themselves have, let's just say they have coronavirus, so that would qualify as a serious health condition under the FMLA,
Right.
they would be entitled to 80 hours of paid sick leave, but they don't get paid FMLA after the 80 hours of sick leave
Right.
for their own serious health condition, correct?
That's exactly right. The way,
Okay.
well, no, I think you're right under this act. Now, what I see this act as really doing is dealing or focusing more on pay during the quarantine period. That,
Right.
to me, is what this is really about. Congress wasn't interested in expanding paid leave for serious health conditions, even if they are, and we may need Matt to jump in because I don't want to misstate something, but even if they are COVID-19 related reasons, if you're sick for COVID as a result of COVID-19, you're not going to get more than what you would get you're not going to get more than up to 80 hours, okay, more than the
Right.
2 weeks. You'll get time off beyond that, up to 12 weeks, but it's going to be unpaid. Does that sound right to you, Matt?
That sounds right to me. But you also, and this is something we'll talk a little more about towards the end, you have to consider other leave laws or benefits
That's
that
right.
are provided by the employer or collective bargaining
right.
agreement, because all those different sources might afford additional time off, and it might be paid time off, it might be unpaid time off. But the FFCRA makes pretty clear, very clear, that the paid sick leave does not supersede or supplant any of those other types of leave that the employer was otherwise required to provide by policy, collective bargaining agreement, or other applicable law.
Okay, very good. Good. I'm glad we
Right.
clarified that. I think that's very confusing. Thank you both. And then the last element, number 6, the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. I mean, that's just a catch-all. Basically, what you're going to be getting as employers is employees coming to you on the prongs above saying, either I have symptoms or my healthcare provider has said that I'm a high-risk person and therefore I should self-quarantine for 14 days, or my family member has been told by a doctor that they need to self-quarantine for 14 days and I'm their sole caregiver. Those are the reasons that we're hearing employers are getting from employees, and that is going to trigger the sick leave law, the 80 hours as of April 1st, goes into effect April 1st. The question I'm getting is, do they have to have a doctor's note? This does not say they have to have a doctor's note. So my view on this is if an employee represents to you that a healthcare provider has made these recommendations for themselves or for the person for whom they're caring, I would provide the leave. You can ask for a doctor's note, but again, all the guidance is saying physicians' offices are being overwhelmed right now, and if you don't get a doctor's note, you should provide the leave to someone anyway. But note that they do have to still have the condition or the factors that trigger the sick leave. So, you have to look at that law and say, okay, are they asking for, are they describing symptoms or reasons that qualify them for the paid sick leave? All right. So now let's talk about what are the benefits.
Yeah, and one other thing,
go ahead.
Patricia, just to talk about the documentation issue.
Yeah.
The DOL did issue, but didn't issue, it updated its FAQ last night. As far as I can tell, it was last night. And it did answer in one of the FAQs what records an employer is required to keep when an employee takes paid sick leave or expanded FMLA. It provides additional guidance, which I think is helpful. It's still not entirely clear, but it's more, which is better than we had before. And now, so the DOL is taking the position that if an employee takes paid sick leave or emergency paid sick leave under the Act, the employee is required to provide the employer with appropriate documentation supporting the reason for leave, which would include an employee's name, the qualifying reason, the statement that the employee is unable to work, including telework for that reason, and the dates that the leave is requested. The documentation of the reason for the leave is necessary if there's a quarantine or isolation order, or a healthcare provider has advised you to self-quarantine. The DOL said that the employee is required to provide the employer with a written copy of the isolation order or the quarantine order.
Oh, good. Okay, so that's good, because that's different from what there was no guidance on this before, and the statute does not require the doctor's note. So what you're saying is the updated guidance from last night from the DOL says the employer can require the employee to provide a doctor's note in order to take the leave. Is that how you're reading that?
It says appropriate documentation. It doesn't specifically say a doctor's note, and but it does say that if the employee is taking leave because of a health provider advising to take leave, whether it be because the employee's sick, him or herself, or taking care of somebody due to COVID-19, or the healthcare provider has advised to self-quarantine, and you have written documentation to that extent, you have to give it to your employer. The DOL goes one step further and says that if you're, and we're going to talk about this in a second, but for the tax credit relief that's available under FFCRA, the DOL advising that employers should retain any documentation collected for in their records, so that the IRS, if there's an audit or questions about employees taking emergency leave, that the employer is able to show by contemporaneous documentation that the employer collected appropriate documentation to support the emergency leave. And one thing that I've been doing with clients, and I know all three of us have been doing with clients, is advising on paid sick leave request forms, and we can help clients with that as well, to make sure that you're appropriately documenting paid sick leave and that you're having your employees appropriately submit documentation to you. It might not be a doctor's note, but at least you could have an employer-sponsored form that you require be filled out before the employee take the paid sick leave. There might be exigent circumstances where you don't do that, but we're not going to get into those discrete situations on this particular seminar. But the DOL does support appropriate documentation. It does say that certification requirements that were otherwise required under the FMLA are not suspended or stayed pending this pandemic, at least for now. And it does say that an employer can even request documentation to support the school closure or childcare provider being unavailable. And it gives some examples in the FAQ, news articles, emails reflecting that a school or a daycare is closed. So if an employee does request the emergency FMLA for closure of a school or a daycare provider, the DOL is recommending that the employer collect documentation to support that qualifying emergency leave.
Okay, well, that's very helpful guidance. What was your advice? First of all, did the DOL publish any sample forms for the sick leave certification?
No, not yet.
Okay, but they do have the posters. That's something we might get to later in the slide.
Yeah, that's coming up on another slide. I'll talk about the poster in a few minutes. Sal talked about that. But this is just an example for everybody listening of how fast and furious this is coming at us as practitioners and at HR professionals and employers that don't have HR departments because they're small employers. This is all uncharted territory for all of us. I've run out of descriptive adjectives for what we're dealing with because it's several times a day that we're dealing with interpretive guidance or new laws, and we're trying to figure it out immediately on the fly. And the DOL is doing the same thing as well. So to the extent that you have questions or you're unsure about anything, you should certainly consult with your legal counsel because these are difficult, thorny questions. And as Sal said, there's not a long turnaround time on implementation.
So with regard to what the benefits are, the emergency sick leave payments are capped at $511 per day for a total of $5,110. And those are for employees who take leave because of the reasons 1, 2, or 3 above, illness or quarantine. The payment capped at $200 per day or $2,000 total for employees who take leave for the reasons above, numbers 4, 5, or 6, which are essentially caring for affected individuals or for school closure. But as Sal pointed out, the school closure also overlaps with the paid FMLA. Paid sick leave provisions of the Act do not preempt state paid sick leave laws, such as Connecticut paid sick leave. As Matt said in the beginning, these are cumulative. They're on top of whatever existing paid leave the employee may have. Paid sick leave provisions do not diminish an employee's existing rights under a collective bargaining agreement or existing employer policy, meaning PTO.
Yeah, and Tricia, one other piece of guidance that came out with the DOL last night was that with the paid sick leave law, where it's capped and an employee is not making as much as they otherwise would because of the caps, it doesn't reach their salary or their regular wages because of the caps. The DOL has advised that an employer cannot force an employee to supplement that gap with accrued PTO. It has to be up to the employee to elect to use that existing PTO. So an employee could hold on to their PTO, just use the PSL for the 80-hour period, and then after that, use the PTO on top of it.
Is it also the guidance, which I read earlier, that paid sick leave must be applied first before PTO?
Yes.
Okay. Next slide. So are there any exceptions to the application of this paid sick leave? There are. There is an exception for healthcare workers. Now, these are defined under the Family Medical Leave Act. I don't know if we have a slide that is specific as to who the healthcare workers are. Matt, did we put that slide in here?
No, we didn't. But if anybody has a question about this, Patricia, Sal, and I have been working with our healthcare clients to identify healthcare providers. And the real point here is that it's not an exception for healthcare provider employers. It's an exception for healthcare provider employees. It's an exception for the individual and not the entity. So there can be individual healthcare providers within an entity that are exempted from benefits under these emergency paid leave provisions, but the aggregate employer may otherwise be subject to the emergency paid leave requirements, whether it's FMLA or sick leave. So to the extent that anybody has what they think might be healthcare provider employees and they're interested in this exception, they need to analyze the definition of healthcare provider under the FMLA. And it's not intuitive. There are some strange inclusions and some strange exclusions. It's the normal FMLA definition of healthcare provider. As far as we can tell right now, this might change with the additional guidance or regulations, but I think based on a fair reading of the Act, and I think there's even a specific provision that says that the Act is utilizing the normal definition of healthcare provider set forth under the FMLA.
What jumped out at me is that nurse practitioners are included, but nurses are not. And so, for example, if you are a physician's practice with fewer than 500 employees and you are therefore subject to this act, you may have to draw the line at, nurse practitioners are exempt from paid sick leave, but nurses are not exempt from paid sick leave. Administrative staff would not be exempt from paid sick leave, but I believe clinical social workers or certain kinds of, or clinical psychologists are definitely excluded. Other positions we have to look at, as Matt said, on a case-by-case basis. It's not intuitive. So let's go through some more exceptions. Emergency responder employee exception. Again, this is not for businesses. This is for individual employees. Small businesses with fewer than 50 employees may seek an exemption from the requirements, but this is a really high burden. You have to show essentially that you're going to go bankrupt, that it would jeopardize the viability of the business as a going concern. And I think this is an even harder standard to meet now that there are tax relief and payroll relief and other mechanisms by which employers are being supported as they go through this process. The Department of Labor's March 24th guidance instructs small businesses to document why your business with fewer employees meets the criteria set forth by the department, which will be addressed in more detail in coming regulations. Again, I think this is an extremely high burden to meet unless you really are on the brink of bankruptcy as a result of having to implement these new laws. The Department of Labor says don't even seek an exemption on this at this point. I guess they're very overwhelmed, but to document it. If you don't apply it and you document it, in my view, you're still taking a high risk if you choose not to apply the sick leave because there are so many supports now available to small employers. Next slide, please.
So
okay, so here, go ahead.
Yeah, let's. We've got 15 minutes left, and I don't want to go much over. We'll go over for those who want to stay with us, but let's try to get as much as we can done in the hour. So this kind of goes hand in hand with the CARES Act. There are going to be tax credits, and there's going to be other benefits that employers can take advantage of to try to maintain a going concern and economic viability. Under the FFCRA, there are refundable tax credits that will be available to offset the burden of providing these paid sick leave benefits. The IRS has issued guidance concerning how the employer can avail itself of those benefits, and it seems that those benefits will be pretty quickly available to impacted employers by taking a credit against payroll taxes. We issued a blog post on our Murtha employment law blog that includes a helpful example from the IRS guidance if anybody's interested. And also, when we send out the slides later, the hyperlink for the IRS guidance is included here for anybody that's interested in seeing the mechanics of how it will work. On the next slide, we're going to talk about again, unemployment benefits, the expanded unemployment benefits under the FFCRA. The FFCRA was really the second prong of the federal government's stimulus efforts. CARES is the third prong. FFCRA was the first attempt at mitigating some of the deluge of unemployment claims that we're seeing on a nationwide basis. It basically provides technical assistance to states to help set up short-time compensation programs, allowing partial UI benefits for employees whose employers have an approved program to reduce hours to avoid layoffs or furloughs if states don't already have that. Connecticut does have programs. Connecticut right now is allowing for unemployment claims for impacted employees due to COVID-19, whether it be through layoff or furlough. One of the problems with Connecticut right now, though, is there's just too many claims, and I'm seeing reports that it's going to take weeks for unemployment to catch up with the claims. So there's going to be a lag time for anybody submitting a benefit claim today, most likely of weeks. Unemployment under the FFCRA would be, without going into each of these bullet points, it's basically going to provide states with relief for providing benefits due to COVID-19. It's going to provide additional weeks, which CARES does as well. We can go to the next slide. And it grants a lot of money to the states, FFCRA, interest-free loans to the states. All of this is just to help the states avoid going bankrupt from paying out unemployment claims and making sure that states do have enough money to pay employment claims and enhanced employment claims. So on the next slide, we're going to talk about the notice requirements. So Sal highlighted that there are notice requirements under the FFCRA, and there is a helpful poster that the DOL has issued. We'd advise that nobody go out and try to create their own FFCRA poster that differs from the DOL's poster, because you might be setting yourself up for an enforcement action if it mischaracterizes the benefits and the obligations under the FFCRA. Each covered employer has to post in a conspicuous place on its premises. DOL has issued guidance on notice posting requirements. It's made clear that you don't have to share it with recently laid off individuals. You don't have to share it with job applicants, but you do have to give it to new hires or make it available to them either by email, direct mail, posting in a conspicuous place on premises, an internal or an external website. There is guidance that if you have multiple locations and employees only report to one of those locations, or specific employees report to one of those locations, you got to make sure it's in all the different locations. You can't just post it in one and say, that employee could come here hypothetically and see the poster. You got to post it so that people can see it. If you got a newly remote workforce, email it to your workforce. You can blast it out, or you can make it available on an intranet, or you can do a direct mailing. But you can't just sit on it. You have to get out this notice. I don't know how harsh the DOL will be in enforcement actions if they're even going to look to see if the employers are complying. But you don't want to assume that they won't. You want to make sure that that notice gets out. The DOL did make a point of saying, answering the question, I guess they're getting this question, if you run out of wall space, can you just put the required notice in a binder with all your other employment posters? No, you can't do that. And it says you can't put any federal notices in a binder. You have to display the federal notices in a conspicuous place so that it's easily viewed by all employees. And that's the intended audience. They don't want you to hide it. So that's kind of the guidance that we're giving on the DOL. Make sure, notice, get it out there. If you need a copy of it, we can help direct you to it. The hyperlink is going to be at the end of this slide presentation. So just make sure you get it out there. Once you get it out there, you put it in a conspicuous place, you've done what you need to do. So on the next slide, we're talking about enforcement. Sal already highlighted that DOL has a temporary no enforcement period. That doesn't mean that you don't have to comply with the act, and we're not advising that anybody you try to leverage that no enforcement period. You still have to try to comply with the act. It's just if you do something wrong in good faith in that 30-day period, that if you quickly remedy it, that the DOL won't bring an enforcement action. Note, though, the enforcement, the temporary no enforcement period only applies to the DOL. It doesn't apply to any private causes of action that individuals might have. And believe me, we are anticipating there will be litigation that comes out of the FFCRA, that comes out of just normal FMLA. We think there's going to be a lot of litigation. There are private rights of action. So get into compliance as soon as possible. On the next slide, we're going to switch over and we're going to talk about, just briefly, I'll highlight this so we can get to the next slide. If you're not already aware, all the states in which we have offices, Massachusetts, Connecticut, New York, all of those states have their own versions of executive orders or directives that non-essential businesses need to shut down. They're not all the same. There are differences, and there are important differences. So if you have multi-state employment locations, you need to be aware of the differences between those different orders, and you need to react accordingly. And we can help you do that if you haven't done it already. On the next slide, we're going to switch over to talking about Connecticut-specific issues just briefly, and Trish is going to highlight that.
Okay, let's go. So, as many of you are Connecticut employers, and you know that you and many of you have been forced to either lay off or furlough employees. We are. I mean, it's a distinction to some extent without a difference under these conditions, but generally speaking, the furlough is a situation in which you are letting employees go, but you anticipate that they may come back to work. The same can be true of a layoff. So what is happening on the unemployment side in Connecticut is that when you separate employees, whether it's termed a layoff or a furlough, you provide them with the separation package. The Connecticut Department of Labor website walks employees through the application process if they were let go due to COVID-19, the coronavirus situation. And the first question asked is, do you expect to have a return to work date? And they're supposed to answer yes, even if there's no exact return to work date. The Department of Labor website advises them to put in April 1st. At this point, that's not going to happen for any employer, and they're probably going to have to change that date. They're just putting that in there as a placeholder, so it doesn't really matter. If you as the employer are completing the application process, the unemployment forms, and you don't know the return to work date, which who does know the return to work date, just put unknown. So if you decide that rather than do a furlough, and in terms of furlough, some health plans do allow you to maintain health coverage for your employees if you have laid them off or put them on a furlough. You need to check with your broker on that point. And again, the terminology may sound a little better if you say furlough because it raises an expectation, but that the employees will be returned to work. But again, don't promise anyone anything in terms of a return to work date. You can put an estimated, make sure everybody understands it's estimated. And you can also keep your employees on health insurance, for a specified period of time. We're going to do this in 2-month increments and then revisit, for example. But again, on the insurance piece of it, do check with your insurance broker to determine whether your plan would allow you to keep your employees on the insurance coverage even while they're not working. Now, the Connecticut Department of Labor has a program called the Shared Work Program. This only applies if you are going to reduce the pay wages of employees by 10 to 60%. So if you decide that across the board you're going to reduce their salaries or their hourly wages, you can apply for the Shared Work Program. What's the benefit to that? So there's two things. If you reduce their work hours, they would be eligible to apply for unemployment under any circumstances. But if you decide to go through the shared work program, you as the employer assume the burden, take on the burden, the administrative burden of applying for unemployment so that each individual employee doesn't have to do so. And you can adjust compensation, wages on a weekly basis under this program. So in other words, 1 week you cut everybody or certain departments or however you want to structure it by 10%. You don't have to cut all employees across the board by the same percentage, but you can assess it on a weekly basis and change it on a weekly basis. It is available to employers with 2 or more full-time or permanent part-time employees. Okay, next slide. Okay, Matt, is this yours, the Connecticut Recovery Bridge Loan Program, or Sal?
And I just wanted to highlight, I'm not going to get into any depth about this, but there is a recovery bridge loan program the DECD just announced a couple of days ago, up to $75,000 for short-term loans for businesses and nonprofits with fewer than 100 employees, 0% interest for up to 12 months, meant to help small businesses stay open and meet payroll or help pay health insurance premiums. So to the extent that's helpful to anybody, that information is on the DECD's website. And if you need help with that, let us know. We can point you in the right direction. On the next slide, we're going to talk about some New York State-specific issues. And Sal, can you address those for us, the New York expert?
Sure. So on the same evening that the FFCRA was passed, New York passed its own what I like to refer to as its own quarantine leave law, but it took effect immediately. So effective March 18th, 2020, any employer who has employees in New York, okay, so this includes out-of-state employers also, who have employees in New York, have to comply with the New York's paid leave law, okay? And that's been for the last week or so. The New York State Department of Labor has published limited guidance on March 20th. They published some guidance. I find the guidance somewhat unhelpful because it emphasizes more so than this sort of quarantine leave that we're talking about. It emphasizes more New York's paid family leave program and short-term disability benefits. In fact, they have forms for those, and it's really not on point with what people are really interested in knowing about, which is this whole quarantine leave law. So, when does it apply? It applies to all employers, including employers that have more than 500 employees. So, employers who are let off the hook by the FFCRA, they're not let off the hook by the New York law. If small employers have between 1 and 10 employees with annual revenue under $1 million a year, they have to provide unpaid sick days and job protection. However, those employees will qualify for state-funded benefits under the New York Paid Family Leave Program or short-term disability law. Okay, medium-sized employers are those who have employees between 11 and 99 employees. And any employer who has over $1 million in revenue, those employees must receive 5 paid sick days under the law at 100%, and they receive job protection too. Upon the expiration of those 5 paid sick days, they can apply for benefits under the New York's paid sick leave program or short-term disability, depending on the circumstances. Next slide, please. Employees of large employers, that's 100 or more employees and public employees, they will receive benefits for the entirety of the quarantine. That's up to 14 days. Okay, so again, you see that reference to 14 days. That's a reference that's made under the FCC, or I knew I was going to get tongue-tied with that, under the FFCRA. And under New York's law, we're talking about a 14-day quarantine period, and they get full job protection. Okay, so when does the what does the quarantine leave law apply to? Okay, it applies to basically two scenarios, and they're very narrow scenarios, okay? Number one, when an employee is subject to a mandatory or precautionary order of quarantine or isolation due to COVID-19, when that order is issued by the state or the Department of Health or a local board of health or any governmental entity, it does not apply based on a healthcare provider's order of quarantine. So this is really a governmental quarantine trigger. It also applies to the second instance. It applies where there's a child who is subject to a quarantine order and the parent is required to be there for the child. Very similar to the federal law, but again, it does not cover a healthcare provider's issuance of an order of quarantine. In effect, companies or employers with more than 100 employees but fewer than 5 employees will be entitled to the time or the benefits that are available under the federal FFCRA. Okay, these benefits kick in. They run concurrently, but they also cover situations that the federal doesn't apply. For example, where the employer has more than 500 employees. And they might also apply in some other instances in order to provide, let's say, in additional benefits. So, for example, whereas under the federal law you might be entitled at some point to 2/3 pay, you will be able to recover the other third under the New York law. Now, what does the quarantine leave law not cover? It's not going to provide benefits to employees who are asymptomatic, okay, who are subject to quarantine or isolation orders, but they're still able to work remotely. So if they're able to work remotely, regardless of the quarantine order, they are not.
Did we lose Sal?
I can't hear him.
So I think that we lost Sal, so we're going to move on to from the New York stuff because I think he was just about to wrap it up anyway. We have not lost many people, so we have 3 more slides. We're going to just power through those. Since Sal's no longer on the call, if he gets back in, he'll jump back in. But we're going to talk just quickly about layoffs and furloughs. Patricia talked about the difference between layoffs and furloughs. There are subtle differences. A layoff being an actual separation of employment. Furlough, the employee still is the individual is still technically an employee, just on an unpaid administrative type of leave. You wouldn't have to rehire somebody if you furlough them because they're still your employee. And under Connecticut law and other states as well right now, there are some states that are following this Connecticut's lead. If you are an employee that's furloughed, you can still collect unemployment right now if the furlough is related to COVID-19 related issues. So layoff, like Patricia said, for purposes of unemployment, furlough and layoff really there's not much of a distinction at all. But for some individuals, they'll be able to remain on a group health insurance plan if they are furloughed as opposed to layoff. And you have to check with your broker on that. Some employers are looking into that so that they can keep employees on their group health plan while this pandemic plays out. And I understand some health insurers are allowing laid off employees to stay on group health insurance plans if the employer so chooses. But that's all up to the health insurer, and you'd have to check with your broker to find out. So on the next slide, we just wanted to highlight for everybody, to the extent that you're considering group layoffs or business closures, or you're temporarily suspending operations, there might be WARN Act implications on the federal level if you're a larger employer, generally over 100 employees. You're looking at, but there's a lot of different math requirements that go into WARN Act. So if you get to the point where you're thinking of suspending your operations, you have a group of employees that you're looking at laying off or furloughing, where you're just looking at permanently closing, you probably want to talk to your counsel, internal or external, about whether WARN or state mini WARN acts are implicated. There are notice requirements to employees, advance notice requirements under WARN, but there are exceptions, and that's if business circumstances that were not reasonably foreseeable at the time a notice would have been required, or a natural disaster, or faltering business. You might be able to shoehorn COVID-19 into one or all of those different exceptions so that you can get a reduction on a notice or an immediate notice out. And then on the next slide, we just wanted to flag some other issues that employers are dealing with. Some of the I-9 rules have been relaxed. For instance, the requirement to review I-9 documents with employees in person, that's been waived temporarily. There's some other changes to that. Immigration rules are changing. That could be a whole seminar unto itself, but there are some different immigration requirements that have changed on an interim basis. So if you have you have employees that are on visas, you have employees overseas, and you have questions about immigration, you probably want to check to see if anything's been changed in light of the pandemic. Unionized employers, do not forget your collective bargaining agreements. We can't stress that enough. You might not have a duty to bargain over decisions that you're making, but you might have a duty to bargain over the effects of decisions that you're making. You might have paid leave for groups of employees that you might have forgotten about, and you might be making decisions without considering those requirements under your collective bargaining agreements. You just want to make sure that if you're a unionized employer, that you have a holistic view of how the collective bargaining agreement impacts any decisions you're making concerning the operations or changing benefits or laying off employees. There might be bumping rights or seniority or rights to recall that you need to take into consideration. So just make sure you assess your bargaining agreement before you implement any big decisions. And newly remote workforces is something that I know Tricia and we're advising a lot of clients on newly remote workforces. And when you haven't planned for it, it is very difficult. I just drafted a temporary remote workforce policy this morning for a client and sent that out. Just a couple bullet points on things that you don't want to forget. You want to make sure to advise employees that are working remotely that your employment policies remain in effect. Hi, Sal. I covered those few slides for you. That's okay.
Oh my gosh, I was talking. I didn't even realize I wasn't on.
No, it's okay. So we're talking about remote workforces real quick. So I would advise your remote workforce that your employment policies remain in full force and effect to the extent that they're working from home. Anti-harassment policies, discrimination policies, ADA policies, any work rules that you have in place. You want to make sure that they know those policies still extend to them and apply to them equally, even though they're working off-site and at home. Electronic equipment policies, IT security policies. You want to make sure that your confidential information remains confidential. You want to talk to your employees and make sure that they have a secure workspace to the extent possible, that they're not giving out passwords, they're not leaving their computers unlocked. If they have visitors, these are all issues that newly remote workforces really are not equipped to handle on a short-term basis. So we're working with clients around the clock trying to help them get set up with their remote workforces. But those are all things that you need to consider, because if you're dealing with confidential or proprietary information and all of a sudden you don't have protections in place for a remote workforce, that could cause huge problems for you from an operational standpoint, from a trade secret standpoint, from a competitive standpoint. So make sure that you think about all of those issues. And don't forget about other types of paid leave that might be available, or unpaid leave that might be available to your workforce per either local law, state law, or federal law, because as we discussed earlier, those are going to be cumulative in addition to FFCRA emergency leave. So you got to take all that into consideration, and to the extent that you're trying to run any of those laws concurrent, any of that leave concurrent with paid sick leave or FMLA, you're probably not going to be able to. And if you really want to do it, you should check with your counsel first, because you might be getting yourself into trouble. I'm just going to go to 115 because there's just a few other pieces of guidance that came out from the DOL that I think are important to highlight. And I know that Tricia and Sal are getting these same questions on a repeated basis. Are you able, as an employer, or an employee, is an employee able to use paid sick leave on an intermittent basis, or the new qualifying reason for FMLA on an intermittent basis? The DOL's guidance on that and what we've been advising is consistent with this. The DOL's guidance is yes, intermittent leave is available for PSL and for emergency FMLA. But once that 80 hours under paid sick leave is up, this is also an important point, and I've been trying, this has been my interpretation, and now the DOL's confirmed it. If an employee uses 80 hours of paid sick leave for one qualifying reason, it cannot use 80 hours of paid sick leave subsequently for a different reason. So just as an example, if you are under a quarantine order and you use 80 hours of paid sick leave, and then you have to take care of your child because of a school closure, you don't get an additional 80 hours. You get 80 hours, and that's through December 31st of paid sick leave. That's it. Once that 80 hours is exhausted, you don't get it again because you have a different reason. So that's something that we just wanted to make clear, because that question's come up several times. Is the PSL or the emergency FMLA retroactive? No, it is not. So to the extent that an individual had a qualifying reason pre-April 1, they don't get to backdate any types of paid sick leave. And for an employer, this is important because we're getting this question. If you've had an employee go out pre-April 1 for what would otherwise be a qualifying reason for paid sick leave or emergency family medical leave, you don't get that refundable tax credit. You don't get to retroactively apply that. That is April 1 through December 31st, and that's it. So we're bumping up on 115. We've gone over about 15 minutes, so I'm going to stop talking at this point. Tricia's going to wrap up, but thank you everybody for your time. And if you have any questions or you need any assistance, please feel free to reach out to any of us.
Thanks, Matt. And just to wrap up, I think the next slide of what's next, really we should have just put a big question mark there. Who knows? But rest assured that, as Matt said, we're on it. The team has been working nonstop to try to understand and process all this information. I have to be honest, I can't read that fast and get all my work done in 14 hours a day. So thank goodness that we have a team who's able to process all this, understand it, and make it useful for all of you on the call today. So following up, the next slide does have various resources that you can access really right now. I think our website has links to almost everything that you would need, but these are just some summaries that you have on these slides to go ahead and get the information directly yourself. But we've tried on an ongoing basis to summarize everything as it occurs. So hopefully you find those useful. And then if beyond that you need additional help, we're here to help. That's what we're here for, and that's what we're doing. So thank you very much, all of you, for participating, for listening. As Matt said, it's confusing, it's rapid fire, and we're all here to help you and support you in this unprecedented crisis situation. You will all be receiving an email with this PowerPoint and a link to the webinar and an attendance certificate. Again, I want to issue the caveat for those of you who are listening to this recorded. This is all current as of March 27th, 2020. So if you're listening to this tomorrow, things might have changed. A week from now, I'll bet they will have changed. But this at least gives you some fundamental starting points for how you're going to deal with your employees. And the critical date here is coming up very shortly, April 1st, for the application of the paid family medical leave and the sick leave. Thank you all for your time. We greatly appreciate it.